Wonderful. Good afternoon. My name is Whitney Barth. I'm the Executive Director of the Center for the Study of Law and Religion here at Emory Law School. We're delighted to have you with us this afternoon. Thank you so much for coming and for being a part of this discussion. I'm going to turn it over, the floor over now to Dean Marianne Bobinski, who is not only the Dean of the Law School, but Asa Griggs Candler Professor of Law here at Emory Law School, and for brief welcome remarks. Thank you, Dean Bobinski.
I'm delighted to welcome you on behalf of the law school today. This is the Center for the Study of Law and Religion is a globally prominent, globally connected jewel in the Emory crown, and it's a pleasure to be a part of any event that Whitney and her colleagues sponsor. But I must say I'm particularly excited about today's event and having the opportunity to hear from one of our new colleagues about her work and to have important engagement and dialogue about that work available to members of our community and those further afield today. So thank you so much for being here. Thanks to the center for creating the opportunity for this special event. And thanks to Dr. Deepa Das Acevedo and to the panelists for creating this opportunity for discussion today. Thank you.
Great. Wonderful. Well, I have the distinct pleasure of being able to introduce Dr. Deepa Das Acevedo and our colleagues from across campus, who I'll introduce in turn. The way that this day, the rest of our time together is going to go, I'll do the introductions. I will turn it over to Deepa for a few minutes of introduction to the book, and then we'll turn it over to each panelist who will respond. And after each panelist responds, Dr. Acevedo will also have a chance to respond to their comments as well, so that we're meant to have a dialogue. And then we'll open it up to you for questions. And this event is also being streamed on Zoom. So we'll also take questions from the Zoomiverse. Is that a word? The Zoomiverse? If it's not, it should be now. As they come in, and my colleague, Dr. John Bernal, is handling the Zoom. So thank you for that, John. Wonderful. So starting us off, Deepa Das Acevedo is a legal anthropologist and an associate professor of law at Emory Law School. Her research blends ethnographic fieldwork and anthropological theory with doctrinal and policy analysis to provide new insights about legal rules and institutions. In addition to her work on the law and politics of India, she studies employment regulation and it's exploring methodological and theoretical developments in the anthropology of law. Deepa Das Acevedo joined Emory Law School in 2023 from the University of Alabama, where she was an associate professor of law. Before that, she was a Sharswood Fellow at the University of Pennsylvania Carey School of Law. She received both her JD and her PhD in anthropology from the University of Chicago and her AB in politics from Princeton. Her research has been supported by the Fulbright Scholar Program, the American Council of Learned Societies, the Social Science Research Council, the American Philosophical Society, and the Committee on South Asian Studies at the University of Chicago, and the Research Grants Committee at the University of Alabama. The monograph that we're discussing here this afternoon is the Battle for Sabarimala, Religion, Law, and Gender in Contemporary India, which is forthcoming from Oxford University Press. Professor Das Acevedo has many different publications, which you can find on her faculty page on the website, so I encourage you to check out that list to familiarize yourself with the broad range of her work. Now, turning to our first panelist, Dr. Harshita Kamath is the Kopaka Associate Professor in Telugu Culture and Literature and History within the Middle Eastern and South Asian Studies Department here at Emory. She has a BA from Emory, a Master's in Theological Studies from Harvard Divinity School, and a PhD from Emory University. Her research focuses on textual and performance traditions of the South Indian language of Telugu. She has published in a number of peer-reviewed articles and has a number of books, and her work has been supported by grants from the American Institute of Indian Studies, Fulbright Hayes, American Association of University Women, and National Endowment for the Humanities. So thank you, Dr. Kamath, for being with us this afternoon. Our second panelist will be Dr. Don Seaman, who is an anthropologist and associate professor in the Department of Religion and in the Tam Institute for Jewish Studies. His scholarship, from his ethnography of Ethiopian Israelis to his textual studies of Maimonides and Hasidism during the Holocaust, is motivated by the attempt to understand and describe the existential context and meaning of religious experience in all of its forms. He is the founding co-chair of the Emory Forum for Ethnographic Study of Religion and co-edits Contemporary Anthropology of Religion book series at Palgrave Macmillan, and serves on editorial boards in both a number of different journals. So thank you, Dr. Seaman, for being with us this afternoon. And finally, Dr. Samina Mullah is an associate professor of women, gender, and sexuality studies at Emory University. She uses anthropological approaches to examine the intersection of law and healthcare in the U.S., interventions in sexual violence, and the ways in which they are invested in regimes of gender, race, and power. In particular, her research maintains a focus on the ways in which healthcare law and policing configure sexual violence as a social and political wound. She has written several books and is the founding co-editor of Feminist Anthropology, the official journal of the Association of Feminist Anthropology, and is the editor of several other series. So thank you, Dr. Mullah, for being with us this afternoon. So with that, I will turn it over to Dr. Deepa Das Acevedo. Thank you so much.
Thank you all so much for being here. The publication of a book always involves a lot of vocalized gratitude, but I will try to keep mine to a minimum. First, I'm grateful to Dean Babinski and to Emory Law for the support they've shown this project and me so soon after my arrival. I've come to learn that an enthusiastic welcome is an Emory trademark because no fewer than 3 of my new colleagues, Samina, Hashita, and Dawn, all agreed to take time away from their own work in order to engage with mine, and they agreed to do this long before I'd even set foot on campus. I'm also grateful to Whitney Barth and Kenyatta Greer for organizing this lovely event, which more than anything else makes me feel like I might have actually written a book. Of course, without the support of a writing fellowship from the American Council of Learned Societies and the Luce Foundation, and without a dissertation grant from the Social Science Research Council, there would be no book in the first place. So I'm grateful to them as well. Finally, I'm grateful to the 2 people sitting over there, my mother, Malika, and my husband, John. Over the years, they've made this research possible and kept this research fun. They are my first and favorite collaborators for all projects. But I also want to take this opportunity to thank a few other people whose contributions to this book may be less obvious, but without whom there would also be no book. Taken as a group, these people exemplify contradictions and complexities that made this book and the dispute that is at its core so fascinating to me for almost 20 years. Krishna Kumar Mangote was appointed by the Kerala High Court to help its Devaswam Ombudsman with temple administration matters. That title makes it sound like Mangote was just a kind of research assistant, when in actuality, his subject matter knowledge and the professional network that he'd built up over decades of practice made Mangote more like a threshold adjudicator. 90% of the lawyers I met were people who I met through Mangote. And so it goes without saying that most of my credibility came from him too. I wish he had lived to see the book that benefited so much from his knowledge of regulatory structures and power dynamics, although I can't say with any degree of confidence that he would have approved of it. Bhakti Pasuja Sethi is one of the many attorneys who practice at the Supreme Court of India, but she was the one who filed the lawsuit that eventually led to the formal, if not the functional, prohibition of Sabarimala's admission practices. Despite being on the receiving end of a lot of negative commentary, Bhakti was kind enough to speak with a grad student who was still figuring out exactly what it meant to do ethnography. When I spoke with her again during the writing of this book, she told me that she hoped I would produce something suitably inspiring and equality affirming, something that would champion the cause of women's entry that she herself had been championing for so long. I don't know if she'll be satisfied with this book either, but I look forward to finding out. Finally, I want to express gratitude to Rahul Ishwar, a person who couldn't contrast more with Mangote in terms of professional expertise or with Bhakti in terms of political ideology. Ishwar is a member of the family that supplies Sabarimala with its chief priests, and he spent most of the last decade operating on the fringes of Hindu nationalist politics. But he was every bit as generous with me as Bhakti and Mangot were, and I'm no less indebted to him because I don't share his vision for Indian society. The battle for Sabarimala, as I find myself saying more and more often, is not only a battle for India, it's the kind of battle that is essential to India. It is, in fact, the kind of battle that can draw in an Orthodox Hindu priest, his media-savvy grandson, an astrologer, a minor actress, various religious associations and their feminist others, a housewife turned activist, a college student, polished New Delhi lawyers, phlegmatic communist officials, a bachelor deity, a handful of Supreme Court Chief Justices. I'm so grateful to everyone who's helped me explore the contours of this particular battle over nearly 2 decades of research, and I'm especially grateful to share that adventure with you now. Thank you.
Can everyone hear me? Okay, great. So thank you to Whitney Garth and the Center for the Study of Law and Religion for the opportunity to read and reflect on Dr. Das Acevedo's book, The Battle for Sabarimala, Religion, Law, and Gender in Contemporary India. Although I've been at Emory for many years, in many iterations, I've actually not crossed over Clifton Road to engage with faculty and students at the law school, so I very much appreciate this opportunity. At the outset, I want to begin by noting that Dr. Das Acevedo's book is beautifully written, interspersed with her ethnographic observations and lengthy discussions of the various judicial proceedings related to the Sabarimala case. Dr. Das Acevedo's book is peppered with pithy comments that are sharply astute and humorous in tone. My favorite line shows up in chapter 1, where she writes, quote, "Indian secularism, it is worth saying, is every bit as secular as French fries are French," end quote. I laughed out loud in the car after reading this line, and then I read it out loud again to my partner who was driving and quite bewildered at my delight in reading an academic monograph. Dr. Das Acevedo is indeed a gifted storyteller who draws the reader in, despite their lack of familiarity with the intricacies of the Indian legal system. If you think this book is not for you, I assure you that it is. Integrating ethnography, constitutional law, and religious practice, the battle for Sabarimala has everything for everyone. Or to quote Dr. Das Acevedo, quote, "Too much law for anthropologists, too much society for lawyers, and too few archives for historians," end quote. This caveat aside, the battle for Sabarimala provides an extensive account of the Sabarimala temple entry controversy and the legal battles that ensued. As Dr. Das Acevedo has already mentioned, Sabarimala mentions in the book, I assumed you had mentioned it when I was writing. As she mentions in the book, Sabarimala is an important pilgrimage site in Kerala, South India, that is dedicated to the celibate regional deity Ayyappan. Kerala, which is known for its high literacy rate among women and religious syncretism among Christians, Hindus, and Muslims, is also home to some of the most orthodox Hindu temples in the country. As Dr. Das Acevedo writes in chapter 1, quote, "Correct ritual observance is a matter of pride. Our politics may be more progressive than yours, but our temples are more discerning and our Brahmins are more rabbinical," end quote. Kerala is both an exception and the rule, thus a fruitful starting place to examine the intersections of Hindu religious practice and Indian juridical discourse. Those who have visited South India in the winter have likely come across Ayyappan male devotees who are undergoing the arduous Sabarimala pilgrimage. Often clad in all black and barefoot, Ayyappan pilgrims take on a 41-day fast, after which they begin their pilgrimage or yatra to the Sabarimala temple. Just as often as one might see these black-clad men walking around the streets of South India, or even your auto drivers are often doing the Sabarimala pilgrimage, or Uber drivers, one is also likely to hear about the controversies related to the entry of women into the Sabarimala temple. I would even conjecture that the growing number of groups of male Ayyappan pilgrims in recent years is perhaps the direct outgrowth of the 2018 ruling allowing women's temple entry. As women began to enter the temple, male Ayyappan devotees have increased their religious fervor in claiming Sabarimala as theirs. While there are many things that I can comment on related to this book, given the nature of this particular panel and the expertise of my esteemed colleagues, I will keep my observations limited to the domain of caste, gender, and Hinduism. At the heart of this book is the conundrum regarding the Indian Constitution and its dealings with religion. Harkening back to the earlier comment about Indian secularism being as French fries, Dr. Das Acevedo observes that despite the preamble of the Indian Constitution underscoring India as a sovereign, socialist, secular republic, the envisioning of secularism is not one that we may be familiar with in the West. In the Indian Constitution, religion is not set apart from public secular life. On the one hand, the Indian Constitution touts religious freedom, and on the other hand, it intervenes in religious practice, particularly through Article 17, which abolishes the casteist practice of untouchability, and Article 25, which allows for the state to open Hindu religious institutions to all classes and sections of Hindu society. As Dr. Das Acevedo notes in chapter 1, quote, alongside the impulse to reform religious life, there has always existed a recognition that religious life merits protection, end quote. Important in the Sabarimala case is the colliding of caste and gender within legal discourse. In early 20th century India, caste-based temple entry was an important issue for framing the new Indian Constitution. And there was a legal investment in making sure that temples, Hindu temples, were open to members of all castes, not just those from dominant caste backgrounds. By the 21st century, the discourse on temple entry shifted from caste to gender, as seen clearly in the Sabarimala case. In 2018, when the Indian Supreme Court finally ruled to permit women of menstruating ages to enter Sabarimala, two majority opinions by Justice Nariman and Justice Chandrachud specifically link ritual purity with gender. Justice Nariman's majority opinion raised the topic of menstruation as ritually polluting, while Justice Chandrachud's majority opinion examined whether gender exclusion based on ritual pollution constituted a form of untouchability and was thus prohibited by Article 17 of the Constitution. These Supreme Court opinions illustrate the collision of caste and gender in the legal responses to the temple entry case. But I am left wondering about the intersectionality of caste and gender, and not simply the intersections of these two domains. In chapter 2, Dr. Das Acevedo notes that the first two women who finally entered Sabarimala on January 2nd, 2019 were Bindu Amani, a Dalit activist and lawyer, and Kanaka Durga, a government employee from Kerala of the Nair caste. I would ask Dr. Das Acevedo, what do you make of the caste background of these women and other women protesters who literally joined hands to protest against Sabarimala's temple entry practices? Does the caste background of the lawyers, activists, and protesters involved influence the ways in which they responded to the Sabarimala case? Related to this, in chapter 6, Dr. Das Acevedo underscores the efforts of activists Nikita Azad and Trupti Desai in the Sabarimala case. The campaigns that were spearheaded by Azad, Desai, and their supporters underscore that the issue of untouchability in the Indian Constitution, in Article 17, is not only about caste, but also about gender. Dr. Das Acevedo writes, quote, if one of Hinduism's worst features has impacted members of other faith communities, Azad's and Desai's campaigns make it abundantly clear to anyone still entertaining doubts on the matter that menstruation renders even Hindu women both briefly verboten and eternally suspect with respect to their ritual purity, unquote. In short, the concept of untouchability, and I'm putting this term in quotes because it actually is in quotes in the Indian Constitution, prohibited by Article 17. This concept of untouchability in this reading of Azad and Desai's campaigns not only pertains to members of marginalized caste backgrounds, but can also refer to menstruating women who are deemed ritually impure. I am intrigued, but I am also worried about the nature of this interpretation, which refashions the legal category of untouchability to include both Dalits and women. Does such a reading mean that Brahmin women, who are often the gatekeepers of Brahminical patriarchy, in the words of Uma Chakravarti, can claim the status of untouchability in juridical discourse? What happens when Article 17 is interpreted in this way to expand the domain of untouchability beyond caste to gender? What kinds of violence does it enact on Dalit communities, relate caste and gender in the eyes of the law? What kinds of violence does it ignore? I'm also curious, Dr. Das Acevedo, about your choice of language. Throughout the book, you refer to Dalit activists such as Bindu Amini as Avarna, literally without caste, but not as Dalit. What choices did you make when discussing the topic of caste, and how were these choices influenced by your interlocutors and or legal discourse? Also related to caste and gender, there's an interesting appendix, by the way, that has these kind of methodological interventions in the book. I've left it to my colleague Don Seaman to really talk about this a little more. But in the appendix is where the methodology comes out, and the book is framed as a constitutional ethnography. Now we get Dr. Das Acevedo's authorial presence and family background threaded throughout the book, but I wanted to ask her to reflect more on her gender and caste positionality, and particularly how this positionality affected her interactions in the field and when writing the book. And my last, rather next kind of disparate question that's sort of unrelated and probably a loaded question is, what happens next in the story? In the conclusion, Dr. Das Acevedo outlined some of the various events that followed the 2018 Supreme Court ruling, and I'm wondering if she can give us a 2023 update on the status of Sabarimala. And there's also something in the book that I found, there were sort of references to Hindu nationalism, and then maybe some pulling back. And I'm wondering, what can you tell us that you couldn't write in the book about the impact of Hindutva and the Sabarimala case going forward? I want to thank you so much for sharing this beautiful book with the Emory community. And thanks again to the Center for the Study of Law and Religion for inviting me to be part of this conversation.
Thank you so much, Harshita. That was a lovely set of questions and interventions to get the conversation going. I appreciate it. I'm going to take your questions more or less in order. So to the first question, whether the caste backgrounds of the women who were involved in protesting against both the ban and its judicial overturning, as well as of the women, the two women in particular who were, to our knowledge, the only ones within the age range intended to be successful at actually visiting Sabarimala, Bindu Amini and Kanakadutta. As far as the protesters, the ones who participated in the public rallies and the human chain called the Women's Wall that happened in early January of 2019. I don't know, I don't have a sense of the aggregate caste identities of all of the many hundreds of thousands of people who would have been involved. But I think as far as the two specific women who visited Sabarimala in January of 2019 are concerned, I do think that those identities are worth pausing to reflect on. Bindu Amini is a lawyer and teacher and activist, as well as a fairly active member of the Communist Party of India Marxists. Kanakadutta was, at the time that she participated in her visit to Sabarimala, a housewife. And I think it's no coincidence that the lawyer, teacher, activist, and the housewife came respectively from lower caste and upper caste communities. I say this because with a little bit more confidence than I would normally say this sort of thing,
because they were brought together by a single purpose social media account that was developed in part to facilitate the entry of women in the prohibited age range to Sabarimala. And as with impact litigation everywhere around the world, including in the United States, you choose your heroes carefully, right? To your second question about the refashioning of untouchability in the Indian Constitution's Article 17 to incorporate not only caste-based forms of ritual exclusion and pollution, but also perhaps gender-based forms as well. I share your concern. I think that there are seriously troubling questions to be raised in terms of when we read Article 17's prohibition of untouchability to include all forms of ritual pollution and exclusion. That said, I do think that the language of the Constitution makes it not possible. Very few things are truly impossible when it comes to legal interpretation writ large, constitutional interpretation writ slightly less broadly, and certainly the Indian Constitution most specifically. But it's hard when it comes to the Indian Constitution in Article 17 to argue that gender-based forms of exclusion and ritual pollution should self-evidently not be within the ambit of what Article 17 prohibits. That does mean that Brahmin women could potentially claim the mantle of Article 17's protection. They can't yet, because Justice Chandrachud's opinion, which was the one that elaborated on this particular interpretation of the article, was not a plurality opinion, but he is now the Chief Justice. So that interpretation may be gaining more traction moving forward. My choice of language with respect to how I refer to people like Bindu Amini who come from castes that have been traditionally considered outside the fourfold Varna system is certainly an intentional choice. I'm not 100% sure that I would make the same choice again, but I do know that if I were to make the same choice again, I would include my rationale about that choice, which was to refer to people who belong to castes traditionally considered untouchable as Avarna instead of as Dalit. Is like the naming choices I made when referring to places, geographic places in the book, one that was born largely of what I encountered in the field and around me. That's not to say that everyone I spoke with or every article that I read used Avarna instead of Dalit. I actually think that Avarna, Dalit, and scheduled castes, which is the legal and bureaucratic term assigned to many, although not most of the people who might fit into the other two categories, are relatively equally used within the Kerala context. So that's a way of saying that on the one hand, the usage of Varna was contextually familiar to me in the same way that referring to Cochin as Kochi, but Thiruvananthapuram as Trivandrum, using alternate vernacular or anglicized names for places, was familiar to me. It's also partly a decision that was inspired by the subject matter, temple entry, and the particular events that have not only occurred with respect to temple entry across India, but in Kerala specifically. Two of the landmark temple entry agitations that kind of bookend now our understanding of temple access, Hindu temple access in India, occurred in Kerala. The language that was used certainly at that time was overwhelmingly Avarna. That in and of itself isn't a justification for using the same language now, but it is part of that broader story. And I think this is the reason why many, though certainly not most, scholars who are themselves of Keralite origin, writing about Keralite politics, like actually Jay Devika, I came across one of her recent pieces on the Sabarimala temple dispute, have kind of alternated between these various terms, in one piece using Avarna and another piece using Dalit. To your last two questions, I'll try and be quick. As far as my own gender and caste positionality, there's no way that one's demographic markers does not impact one's access and interactions in the field. And for sure, being a much younger, small, brown woman of obviously Keralite origins helped me in a bunch of ways when I was doing my research. I was unthreatening, deserving, respectable, all without having to say anything. I was also neither nor as far as caste loyalties was concerned, precisely because I belong to a subset of the dominant Nair caste. So I was neither self-evidently on the side of temple authorities and the priest family because I was not a Brahmin, but I was also not self-evidently on the side of women who wanted to enter Sabarimala, kind of crudely epitomized in the figure of someone like Bindu Amini, who is a Varna, right? Predictions going forward. I do have some predictions, actually. And again, this is something that I usually try not to do. I think we have seen the last of the essential religious practices doctrine. This is the doctrine that emerged in 1954 and has been on the chopping block virtually since the Sabarimala decision was announced in 2018. The current court, meaning the court headed by Chief Justice Chandrachud, is at pains to effectuate a broad-scale reformation and re-understanding of the judiciary, and the current administration is at pains to implement much the same thing, although with different implications, motivations, and connotations with respect to Indian legislation. The Indian Penal Code, which was written by Thomas Macaulay in the late 19th century, is currently on its way out. So I think it's not a great stretch of the imagination to say that a judicial decision and test that was developed in 1954 is on its way out as well. And I think that in turn is going to show us what either complete non-intervention in religious life in India or more complete state intervention in religious life in India is going to look like, and give us an idea of why both of those things have significant drawbacks.
Turn to our second panelist, Dr.
Sure. Can you hear me in the back? Thank you. It's nice to be here. I'm in the religion department here at Emory, and I know that many of my colleagues are looking forward to increasingly robust collaboration with the program in law and religion here. I met Deepa last year at a conference of the Society for the Anthropology of Religion, and was really very happy to hear that she would be at Emory. Deepa has her law training from Yale and her anthropology training from Chicago, which is sorry, not Chicago?
Not Chicago.
Oh, sorry. Oh, Chicago. Okay, my mistake. But in any case, that's a little bit like playing both for the NBA and the major leagues, which is quite rare. And although I've had a chance to read her book, I'm not sure that you all have. It is true that it is a readable book, and it has something for everyone. Of course, you can't do that without sacrificing some things. Now, let me say that I'm not an expert on India by any means. Nor am I even really a legal anthropologist in that sense. Years ago, when I was in graduate school, I focused in medical anthropology, but one of the members of my committee was Sally Falk Moore, who was an early, strong voice in the creation of a separate field called legal anthropology. And in her younger years, before she became an anthropologist, she was actually on the American legal team in Nuremberg, the Nuremberg trials. And after that, for a number of reasons, chose anthropology rather than law. She never enjoyed the same success as her medical anthropology colleagues did in penetrating the professional school. And anthropology lags behind a field like medical anthropology in terms of not only positions in law schools, but also in terms of legal scholars and lawyers and courts finding a use for anthropology in the way that doctors and hospitals and public health officials have. And I think that's worth just reflecting upon. And one of the things I would love to hear some reflection from you about is where do you think this field is going? I was very delighted that Emory chose to hire a legal anthropologist. It was a surprise to me. I'm happy about it. But where is this heading? Is this something that students are demanding? Is this something that has been put by theoretical concerns? I'd be very curious to know what your thoughts are about that. Now, stepping back from the particular study of this shrine or temple in India, something about the different fields that this book addresses. Anthropologists often give short shrift to law. And despite the fact that anthropologists have written about law constantly from the very beginning of the field back to the late 19th century, where they were interested in comparative law involving Roman and Greek and biblical origins, and they were comparing that with what they thought were the laws of savage societies, as they would put it. And there were these huge comparative compendiums that were compiled. However, as that kind of anthropology fell out of fashion, anthropologists began increasingly focusing on what they called culture. Culture includes practices and prohibitions and obligations, which you might think of as law, but they tend to be less necessarily self-conscious. In fact, some definitions of culture insist that culture is what you don't realize is behind the decisions and choices that people are making. It's it's behind the doxa. It only comes into clarity after it's been challenged or when it's on its way out. But every human community has culture, and every human community is influenced by it. But anthropologists have, for the most part, in my view, not given sufficient attention to the autonomy of legal systems as forms of discourse within particular cultures. In other words, law has its own rules and its own way of talking about things, its own ways of describing legitimacy that are grounded in culture but are not reducible to culture. And I say that as a non-lawyer, so you can feel free to dispute me. But as somebody who knows a little bit about some systems of religious law, Jewish law in particular, and is an active observer, at least, of American constitutional law, one of the things I think anthropologists and some sociologists miss is the idea that law is its own thing. And it's not only purely policy driven. Right? You may reach a constitutional conclusion about a topic that is in tension with or even at odds with your personal policy preference. Okay? And the very fact that that can happen means that there's something going on in law that needs to be held up and observed on its own terms. Now, at the same time, legal scholars and lawyers among them have tended to neglect very much culture and tend to portray legal systems as being kind of the same wherever they are. And we even talk about Jewish law and Islamic law and Hindu law as if those are similar in some way to British common law or American constitutional law. The word law covers a variety of sins. And we're kind of prizing out what we mean when we even use those terms. There have been books written about Brahmanical law and Vedic law, which don't have very much to do, it would seem, with a project like yours. And I'm curious whether you see an overlap between those projects by anthropologists, among others, who are talking about a very different kind of way of adjudicating principles. Furthermore, I would argue that neither law nor anthropology tend to do very well at describing lived experience of individuals and groups. And this is changing somewhat, but it still is a minor interest, I would say, in social science. And lived experience, of course, is not reducible to culture or law either. One of the things that I found myself wondering as I was reading, and I did see more of it in the epilogue than in the book. The book, by the way, is blessedly free of anthropological jargon or legal jargon for the most part. And I think that makes it very readable. But at the same time, it left me wondering as an anthropologist, what were the quality of the experiences the anthropologist was having upon which she bases this very rich discussion and set of conclusions. And Deepa very self-consciously writes that she saved that for the epilogue for a variety of reasons. And that may affect who the final audience for the book is. But I'd also like to hear even more about that. What were the quality of the lived experiences? A lot of what you're describing is historical. Some of it is based on interviews. How did you decide who you were speaking with? What was your participant observation like? And those are not things necessarily I would expect you to address today, but that I would love to hear about maybe in a future work. Finally, when I was thinking about something like the essential religious practices law in India, which is not something that I had heard about before, it immediately began about processes of modernization and reform in a whole variety of different contexts and societies. So, for example, just to choose an example that I'm familiar with, in the 19th century, as Jews in Europe tried to navigate and negotiate their place in the new system of nation state, those arguments that led to what we today call Reform Judaism or Orthodoxy or secular Judaism and so forth, which were not categories at the beginning of the 19th century, all turned on what were essential religious practices. And that language was actually used. What is essential? What is not essential? What can be changed? What cannot be changed? And different people's answers to those questions are what led to later social divisions that are now very hard-baked. So it's interesting to see a national legal system trying to address some of that in real time. In the Jewish world, this took 100 years. It's not completely settled. Major answers have all been explored pretty well. I wondered about that sort of comparative dimension. There must be many ways and many places in which the argument over what is essential is really the fundamental constitutional problem. And in India, the fact that the law tried to define what is essential struck me just as a Westerner as surprising. And but when you think about it, if you think closely, you'll find that there are American court decisions which try to do the same thing, which have to determine what is law, what is religion for a purpose of law. Is transcendental meditation a form of religion? Courts in New Jersey ruled that it was, despite the fact that the organization itself insisted that it wasn't back even in the 1970s. And so this question of what is an essential religious practice or an essential religious purpose is extremely important. And I'm not sure that it can be fully resolved by a secular state apparatus, but I could be wrong. The country I know about more, Israel, is in the midst of a tremendous constitutional crisis. And this week, the full panel of Supreme Court justices sat down in part to decide whether to force the parliament to write a constitution, assuming that they have the power or the authority or the persuasiveness to force the parliament to write a constitution. And one of the thorniest issues that's going to come up there, if they try, is going to be this whole secularity, religion, state. What's an essential religious practice? Everybody understands that state policies impact religious practice and the other way around in any society, in the United States and India. But the question is, how do you figure out how to adjudicate? What are the grounds on which those arguments might turn? And finally, just because I don't want to take up too much time, I would say that many people understand culture to be a series of shared practices, meanings, shared more or less evenly through a society, maybe with some differences among different caste groups or something like that. What makes law different than that is both that it becomes at some level, the categories become self-conscious and argued about. But the very fact that it exists for the sake of negotiating the principles on which it's based or arguing about them. I think that the kind of underlying subterranean stream of culture and the more explicit way that people in law think about the problems that they're dealing with need to be better integrated in our understanding of what's going on. And I would personally argue that the way to do that is by looking at the lived experience of individuals and groups. Mine are constrained or enabled both by cultural forms and by legal statutes and apparatuses. How is law used as an affordance to allow people to do things in particular ways? How does it constrain them from doing things or from being in particular ways? I think those are all questions that are raised by this book. This book does not attempt a full comparative or fully theoretical discussion because it's really focused on the immediacies of the Indian case. And I fully understand that, and I think that was a fine decision for this book. But given the breadth and depth of this scholar, of this author, I would look forward to a future work that addresses some of those issues more head-on.
That's all done. Thank you. That gives me a chance to talk about a few things that, unfortunately for all of you, I love talking about. I think I'll begin with what I'm choosing to interpret as your fourth question on kind of essential religious practices in a comparative perspective. As it happens, towards the end of finishing up this manuscript, I was working on a chapter for an edited volume on the essential religious practices, doctrines, travels across Asia. And because India carries a fair bit of judicial influence within the region, among other reasons, the doctrine has traveled quite widely within South and Southeast Asia. And it has unsurprisingly been transformed as it goes along those journeys. The people who are authorized and the decisions that they are authorized to make are some of the things that change as it goes from India to Pakistan to Malaysia to Indonesia to Sri Lanka or not. But the idea that some hierarchy of adjudicators other than an internal ecclesiastical hierarchy is responsible for resolving what may or may not count as legitimate religion is something that is no longer unique to India, even if that concept and a system to kind of enact it is probably most fully fleshed out in India. And I think, you made a comment that on the one hand, sitting here from a North American perspective, the idea of a formal legal system attached to a state apparatus determining what counts as religion or not is surprising, but then it's also not surprising. And American courts do this all the time, even maybe not in a spectacular fashion, but they do it nonetheless. And I think that that's a point that's worth underscoring because we think that the Indian Supreme Court saying that a particular temple may not uphold a practice that it claims is longstanding and essential to that temple's tradition is unimaginable outside and maybe especially in here. But a lot of the questions that arise in maybe more striking fashion in the Indian context or in other contexts are along a spectrum that can be seen in most parts of the world, and certainly even in the context of an American jurisprudence that is built on an understanding of secularism as a wall of separation. To your third question on the
Don't
field
have
work.
to add it all.
I'm going to answer a few of the questions. So the fieldwork is something that exists in an interesting and not usual relationship to the book that it produced. One of the things that I mentioned in the introduction is that the fieldwork that this book is based on was not meant to produce a book on the dispute over women's entry. It was meant to study secular governance in India using the lens of temple administration. The temple I eventually settled on was Sabarimala, but the dispute over women's entry was just one chapter in 5 or 6. And for a long time, it wasn't the chapter or the incident or the series of illuminative of whatever we might have to say about secular governance in India through the lens of temple administration. This is really one of those circumstances where events have dictated actions on my part in a way that I probably could not have predicted. And so the background understandings of constitutional law and state regulatory forms that are seated everywhere throughout the book are definitely a product of the fieldwork that I undertook. The days that I spent sitting in the Kerala High Court, watching a dedicated bench that was assigned to hearing temple administration matters. The interviews I conducted with litigants in temple disputes, the lawyers who represented them, the government appointed lawyers or privately appointed lawyers who represented temples and temple boards, the priests, the devotional association leaders, the journalists who tended to cover the religion beat or the law beat for various newspapers. All of that was done with a view to understanding secular governance in India, and therefore it kind of upholds the book. But the specific dispute was just one part of that, and I've actually spent a lot more time talking to people about it after finishing the great bulk of my fieldwork than I ever did while I was in the field. The last thing I'll pick out, because this is something I love to talk about, so I'm so pleased that you asked about it, is I think 2 interrelated questions about law and anthropology as disciplines. One is, where do I think the field is heading? And I think built into that was a question about where do I think the interaction of the field from an institutional perspective is heading. This is something that I've devoted a lot of time and energy to over the last years. The year that I went out market for a law faculty job was the year I turned around and started talking to other anthropologists who study law and asking them, what did they think of this whole business anyway? And we've been conducting a series of roundtable conversations that hop between our 3 biggest professional associations, the AALS, which is the main academic law conference, the American Anthropological Association, and the Law and Society Association. We put together a series of workshops. We published 2 special issue journals discussing where exactly are these fields going, and is that direction singular or heading in opposite corners. The name of this traveling roundtable, I think, really captures what I set out to ask my friends and collaborators, and not meant to be, was meant to be a living homage to a particular singer. It was, what's law got to do with it? I agree that law and anthropology could be in conversation with one another, but are not. so much anymore, either in terms of the presence of anthropologists in law schools or the seriousness with which anthropologists consider formal law or recognizable legal systems, is, if not a problem, a source of dissatisfaction. I think that lawyers and anthropologists alike lose something when they forget to take one another's methods and theories seriously, which I think has happened for the last 40 to 50 years. But I also think that there are exciting developments on this front. Actually, by a pretty surprisingly substantial crop of legal anthropologists, many, but not all of them, are housed in law schools. And I think that increasingly what we're going to see is an effort by a group of people who have been formally trained to think in one way and then formally untrained and taught to think in another way, trying to bring those two worlds together. It so happens that they are likely to do that most from the position of a law school faculty job, but I don't think that the interest is any less bidirectional by virtue of coming from one side rather than the other. I'm going to leave it there, but we have lots to say.
I'm going to do my test now. Everyone can hear me. And so I'm a legal anthropologist, so I'm going to resist the temptation to answer Don's question because I have a particular take on that as well. But I just wanted to say thank you again. It's a pleasure to come over here. I've been at Emory for 2 years. I'm in women, gender, and sexuality studies, and as I said, I am an anthropologist as well, and affiliated with the department here. And I'm trained at the crossroads of medical and legal anthropology because I took as my search work on gender-based violence, specifically looking primarily at sexual assault intervention here in the US. That was part of my decolonial commitment, was to bring anthropology home. The great myth of anthropology is that it's not of the home, but that is actually something that's quite unique to American and UK trained anthropologists. And if you turn back to our Victorian roots as a discipline and look immediately West Africa and India, where very early anthropology departments are founded, you'll find that anthropology there and in Latin America was always about anthropology of home. And as it so happens, last time I checked, about 90% of anthropology dissertations in the US are about the US. But there's something that happens when those people all go on the market, right? In terms of how we reify this notion of an anthropology that's always elsewhere. So it was a pleasure for me as an ethnographer born and raised in the US, but I don't study India, to read this work, thinking again about whether this is an anthropology of home or of an elsewhere or of both home and elsewhere. And how I think of it as really sort of like firmly within the tradition of Indian ethnographers and diasporic Indian ethnographers turning to India. So the anthropology of India is largely undertaken by Indian scholars. And there isn't so much of a distinction between sociology and anthropology. You might hear the term sociologist used more commonly, in part because anthropology is seen as a colonial endeavor there, and is also associated with more a turn towards the rural. So in urban centers, which is what you study, we would sort of see it as part of those sociological traditions. And I'm parsing through this kind of boring history of anthropology, in part, maybe I'm just feeling nostalgic, but in part because as an ethnographer of the US, I think part of what I'm here to do is to talk about why we in the US should care about this work and engage this work and read this work. And so I will say this, if you are interested or curious about anthropology, this is also true that so much of that Victorian moment, which we think of as the foundational establishing of the discipline, was so heavily reliant on ethnographic traditions in India and colonial Africa, right? So the broad corpus of 19th and early 20th century anthropology really is from those two places in particular. So the way we're all trained, right, even when those figures kind of recede because we become geographical specialists, is always structured by the kind of ghosts of that history. So I think there's always a familiarity when you approach an anthropological text. And then when you have an interlocutor who's as conscious of her craft as Deepa was in writing this book, and you can tell from the work, and I often will tell students, it's very easy to write something that's convoluted and jargon-filled, and that's unclear. It is really indicative of a different level of mastery to talk about things which are quite complex with a kind of deceitful clarity, which I think is what she does. You really ease yourself into the book, and I found myself at points, right, laughing along with it, but also going, what? Wait, I need to read this back. And so I think there are some very intentional choices there, and I think I agree, although editors don't let you put lots of methodology into monographs. They're like, oh, put it in epilogue, better yet, publish it off in an article or something. So I'm sure, though you're voicing, a desire to bring some of your choices into the narrative of the text, there is this sort of like editorial pushback that takes place. But thinking again about the work and where it fits in for me, in terms of legal ethnography in India, I think it's actually in really good company. And I kept thinking about like, what are the most interesting books that have come out recently? So the sort of companionate volumes I was thinking about as I read your work were Kriti Kapila's Nullius, Veena Das's Slum Acts, and Meyer Suresha's recent book, Terror Trials. And then some slightly older texts like Pratiksha Baksi's Public Secret of Law and Srimati Vasu's The Trouble with Marriage. And one of the things that I think your work shares with Kriti Kapila's work is it is refreshingly not cited in Mumbai or Calcutta or Delhi, which I think, again, when you think about what it means to work in the US and to think about legal ethnographic traditions here, or even more broadly speaking, everything we know about crime and criminology and the cities that become the sort of kind of ever-present places within the scholarly landscape, right? So if you read criminological literature ever, there's so much California. Why? Because it has the largest criminal justice system, right, and prison system in the US. And so it tends to be like heavily overrepresented in the literature. Chicago, New York. I mean, we all know which are the places, which are the courthouses that we've read about again and again and again. Kind of delightful insistence on grounding down for the sake of method into the provinciality of jurisdiction, right, as it gets cross-cut by constitutional culture, by national and federal systems, right? And in that, I think there are also these extremely generous and deceptive lessons about method in this particular text. So we've never met, but you would already be sick of me talking about the provinciality of jurisdiction if you knew me in other contexts, because I work on criminal law in the US, and it feels completely kind of unproductive to me not to think about criminal law at the level of jurisdiction and at the level of state. And when you work on issues related to sexual assault, sexual violence, and its prosecution and there, is it's almost senseless to think about trends in the federal law because everything manifests of it. So I won't bore you with too much of that, but I was delighted to read about Kerala because I cannot think in recent history any texts that have really been cited there and have taken so seriously the particular social mores of Kerala in anthropological work or beyond it. Now, of course, there is this sort of omnipresent figure of Nair kinship and Nair polygamy, which is also in kinship studies a source of constant fascination. So it was also refreshing to see a kind of reaching figure of Nair women in particular, right? That didn't seem so over-determined by that anthropological past, right? And there is a kind of like grubby and salacious fascination with the Nair woman. So this really felt refreshingly different. And I was pleased. It was a moment when I was reading the text where I realized how animated it was by your particular positionality, but also by the ethnographic moment, right? You were not engaging a literature which is about a colonial fantasy of the Nair woman. You were allowing Nair women to be complex and part of our present landscape. So I think there's a really, really clever, maybe kind of not the center of the text, but important intervention there for anthropologists. I have to look at notes or else I'll talk for too long. I want to say something again about the ways in which you draw my attention to two sets of issues. One of those issues is the question of sovereignty, which I actually think is not a term that you ever engage, but thinking of it in terms of the way political theorists have engaged sovereignty and the way Western traditions of sovereignty tend to think of sovereignty itself as sort of unitary, unless we're thinking of very institutional and scripted forms of plural sovereignty. Whereas more recent ethnographic work on India, particularly in relationship to spiritual traditions, really gives us a sense of plural sovereignties or multiple sovereignties, some of which are embedded in spiritual authority, forms of governance or institutionality. I thought that there was a really wonderful conversation to be had about the work that sovereignty could or might not do in the work. So I'm putting it out there, but I'm as interested in your reasons for maybe rejecting it or not stopping there. Of course, one book can't do everything. So, don't take this as a sort of sense that you should have done this. But again, it invites a curiosity for me because I see so much in this particular set of conversations and literatures around questions of sovereignty and so much potential to, again, complicate and push back against those particular figures through the work that you've done. I very much enjoyed thinking about how thinking through the site of this conflict and the contours of this conflict invite me to think about gender sex in very, very different ways. So as I was reading the text, I thought to myself, okay, can a god be a jurist? If a god is a jurist, who represents the god's juridical interests, right? Or who's making these claims, right? And is, as the local rumors often go, right, is it the question that Ayappan is really a celibate? Or, right, like when we get back to the story of the best friend, this is one of the way, local conversations that's going on. Is it in fact that, there is a queer Muslim best friend, and is this friendship or is this sexual love? And so, is there a way that we're not able to have those conversations? And this is, again, this is the colloquial conversation that's going on, and it didn't quite make it into, although I think there's like hints of it in the text as well. But it's a patently charged conversation to have that can have no home. There is no queer Muslim space really through which to have that conversation locally there. And it's also a very sectarian kind of dynamite, right, to pose this question. So when we adjudicate the presence of childbearing women in this, or women of a childbearing age in this particular space, are we in fact adjudicating something else, right, that has to kind of persist in silence? So I would love to hear your thoughts on that. There's a very inviting and interesting moment where you ask us to think about separate but equal. And I thought to myself that again, it felt like such an intentional text. And so I wondered, would you say more about what is the invitation that you're asking us to think about, right? Because that is not for an Indian audience, that is patently for us. So is there a lesson there that you would like us to kind of take on board? And I could keep asking you questions, but I think I'm much more interested in giving you some time to work through this and to hear more, if you have more responses to Harshita and John.
Thank you so much, Samina. As always, it is just hugely fun to conversations with you. Even though this is actually the first time we've had conversations in person. Nonetheless, email can be fun. I'm gonna actually answer, I think, your last 3 points kind of in the same way.
Okay.
So both the point you raised about separate versus equal, which is actually the person who made the separate but equal comment to me was Rahul Ishwar. And he made it specifically in the context of saying that men have their space, which is Sabarimala, have their space, which is another temple also in Kerala called the Attikam Devi temple, where once a year there is a festival that only women participate in. But the other 364 days of the year, men are welcome to visit the temple and participate in its ritual practices. So apples to oranges, maybe a little bit, right? But this is part of a longstanding discussion that is not limited to Davalishwar, that characterizes Sabarimala's admissions practices as being, just creating a hyper and celebratory masculine space rather than a space that is exclusionary with respect to women. So the separate but equal kind of moments, the discussion or not of gender, sex, specifically with respect to Vavar, who's most commonly referred to as Ayyappan's friend and follower, a Muslim warrior who has a shrine dedicated to him on the outer perimeter of the Sabarimala temple grounds. And then your other point about discussions of sovereignty or the lack thereof in the text. With respect to all of these, I think the reason that the book, maybe least with respect to sovereignty, the reason that the book doesn't seriously engage with any of these potential moments, even though they are definitely thrown out as kind of lures for an American audience, is because I found myself setting out to write a very specific kind of book, and actually a kind of book that's pretty old-fashioned in some ways, which is a singular case study of a singular dispute over a long range of time. And that's a very old model in legal anthropology, but by virtue of its being sold, it's also kind of out of fashion. And trying to write that while also trying to write a more conventional and contemporary monograph that would fully follow all of the leads that it throws out proved to be beyond my personal capacity. And I think the other reason that I did not really delve into these interesting moments as much as I would have liked to otherwise is because I wrote the book not for me and not for you, but for a reader who is explicitly not a scholar. And I did that in the knowledge that actually nonfiction sells better in India than fiction, which is mind-blowing to somebody based in a North American context, but it does. And this was one of the most explosive disputes of certainly the last several decades. And it just so happened to be a dispute that I had studied for many years. And so I wanted the book to be as manageable, not only in prose style and in theoretical substance, but in its subject matter and the topics that it opened up for the reader's consideration so that the reader didn't come away feeling too overwhelmed. I'm gonna just say something quickly about your comments about kind of the anthropology at home and elsewhere, and about Kerala as an unusual site of relatively unusual site of recent anthropological endeavors in India. I tried really hard to not be a second generation Indian American writing about India and specifically the part of India that my family comes from. It obviously did not work out very well. And I did that in large part because I felt like I was placing myself into a slot that was waiting for me. Part of the reason that slot was waiting for me is concerned with something Samina alluded to, which is even though many, I said it was something like 90%, but I did know the vast majority of anthropology PhDs in the US are situated in the US, they're about the US. There is an overwhelming pressure, or I think pressure is the right word, to not fall into that 90%. I started graduate school with a project that would have been based in North America. And for many reasons, not purely because it was based in North America, I moved away from it. And when I did that, I kind of felt like all bets were off. And if I was going to study in India, out something located in India, then I might as well go all the way and study the topic that was most interesting to me wherever it led me. And it led, naturally or otherwise, to South India, to a handful of temples in Tamil Nadu and Kerala. And the fact that I ended up with one temple in a part of the state where my family, at least formally, was entirely located, and it's now, I stayed with cousins, I had lunch with aunts, that kind of thing, has to do with the kind of more prosaic considerations of fieldwork. You go where you can manage to do a project that is interesting to you, and it so happened that this project was fascinating to me. But the fact that I ended up working in an area that is now relatively rare for anthropologists to work in, even though, as Samina alluded to, it was once, kind of all the rage for colonial anthropological endeavors. It was the only time that India surfaced in my first year anthropology PhD coursework when we talked about kinship and Nair matrimony came up. But the fact that I ended up in that place, I wish I could take credit for it, but I think it has more to do with institutional dynamics and the logistics of conducting fieldwork than it has to do with a desire to make a statement about a choice of place. I did have a desire to make a statement about a choice of topic. That topic kind of predetermined the range of options I had to me in terms of place. Temple entry is also a really old-fashioned topic, so maybe it's no surprise that I wrote an old-fashioned book. It was the kind of thing that was studied extensively, not necessarily by anthropologists, but not to their exclusion either. Decades ago, and temple entry as a legal consideration was among the Supreme Court of newly independent India's first areas of major jurisprudential innovation. But temple entry has not really been on anyone's radar for a long time, or at least it hadn't been when I was trying to develop a dissertation project. So when, I suppose it's kind of fitting that an old-fashioned project produce a somewhat old-fashioned instructor book. Some of the losses there, though, are that you end up streamlining your conversation in ways that make you write articles despite having finished the book.
And the floor. Yes, great. Great. Well, thank you all. One more round of applause. Question, I would invite you to go to the microphone. First person who asks a question, please make sure it's on. We'll take a couple questions before we wrap up. Anybody have any questions for the panel? And or with that, let us know if there's any questions by Zoom. Yes, please.
Hi, Professor. Thank you for, I'm part of Professor Acevedo's legal anthropology class, and we read part of your book for coming here today. And one thing that one of you mentioned was how social media, how some of the people you wrote about met over social media, and how that was able to be like kind of a catalyst for what they were doing. So I guess, could you expound on how social media and I guess our increased connectivity has maybe influenced some of the themes that you write about in your book?
Great, thank you, Constant. So the particular moment when social media intervened in the Sabarimala dispute that we were discussing earlier is when a single purpose social media account created by a man was used to identify and coordinate between potential female visitors to Sabarimala who would make use of the new freedom that they had been granted by the Supreme Court. But social media has played a surprisingly, to me, large role in developing the dispute overall. The initial writ petition for the case that the Supreme Court eventually decided was filed in 2006, just a couple of years before I started doing my fieldwork. It spent almost 10 years kind of bouncing around the Supreme Court in motion practice, which is actually not a whole lot of time in Indian judicial terms. But nonetheless, for 10 years, almost nothing happened. In 2015, 2016, two social movements, one of which was almost entirely consisting of social media activities, really seemed to bring the dispute back to the nation's attention and specifically to the Supreme Court's attention. There were dueling Twitter hashtag campaigns, hashtag happy to bleed, hashtag ready to wait, that concerned the idea that women who were fertile and or menstruating should not go to Sabarimala, or depending on how you kind of constructed the circle, go to any temple at the time they're actively menstruating. Then the second social movement, which involved a kind of local organizer activists who quite literally, not through the media, charged temples that would not open themselves or parts of themselves to women. She had a group of women activists with whom she would kind of march over to various temples around her home state of Maharashtra. And then eventually she decided to target Sabarimala as well. And they would either kind of protest outside a temple's gates or forcibly enter the temple in order to enter the spaces that they had limited access to, her movement also became something of an internet phenomenon. And in the course of these two social movements, which together maybe lasted about 3 months, 3.5 months, the issue of the ban on women came to national attention in a way that it never had before. And within a matter of weeks, the Supreme Court was holding active hearings that were being publicized in national newspapers. And within years, which is lightning speed by judicial standard, there was a decision. Even though this was a kind of old-fashioned dispute that ultimately was resolved in traditional jurisprudential ways, it was moved along at points by forms of communication and technology that quite simply did not exist when the dispute began, to the extent that it has an identifiable beginning.
Any other questions? Do you have any questions on Zoom? The question.
A question from one of our virtual attendees, Shweta Chaitanya. So I'm just going to read her question. She starts by saying thank you so much to Dr. Das Acevedo and the panelists for such an informative panel. This is to Dr. Das Acevedo. Given the religious diversity in India, I was curious if you found similarities or differences in the invocation of a central religious practice in other somewhat adjacent situations where women, caste, and religion are implicated. I'm thinking of the Kerala High Court's response to the protest last year around wearing hijabs in school.
Thank you, Shweta. So the question of being able to wear a hijab in school has been another axis of consideration for the essential religious practices doctrine now for about 4 or 5 years. It's been surfacing in various states around India. And I think that one of the things that is worth remembering that is very often not remembered when it comes to longstanding and reasonably open to criticism doctrines like the essential religious practices doctrine is that they don't throw out predetermined results. They are susceptible to mobilization and co-optation by multiple sides. And the moment that they cease being open to that kind of flexible and multi-party usage is the moment that they become stale and problematic. One of the arguments that's really emerged with the ERP is that it's morphed in its very content in a way that makes it irreparably, unsalvageably bad for believers. It has gone from trying to distinguish between activities and practices and beliefs that are essentially religious and those that are essentially non-religious to trying to distinguish between activities and practices that are essential to a religion or not essential to a religion. And obviously the circle of things that are non-religious is much smaller than the circle of things that may seem religious but are not necessarily essential and can be characterized one way or another as more or less important to the maintenance of religious belief. That slippage has been the source of a lot of criticism and concern over the lifetime of the doctrine. But I think that what we miss in the course of articulating those criticisms is that often essential religious practices is used not by a temple that is trying to keep out and a person desirous of visiting it, but used by an individual desirous of maintaining a practice vis-a-vis the state. The way that the doctrine is mobilized matters and varies hugely depending on who the parties articulating the essentiality of religious practice, whether it's two parties who belong or claim that they belong to the same religious community, or a state authority or a kind of private actor like a school potentially, and a believer who wants to maintain a practice that they hold dear and believe, consider essential to their faith.
Wrap up there. We're at 5:45. Thank you all again so much for your wonderful remarks and for sharing. And Dr. Acevedo, thank you so much for sharing your wonderful book with us. We'll have one request of the audience who's in person. Please eat some food before you leave. But thank you all for coming and for being a part of this event. It was wonderful to have you. Please stay in touch with our center. Let us know if you want to be on our mailing list. We have a number of events throughout the year, but it's just a wonderful conversation. And thank you all for coming across campus and for being a part of this wonderful discussion.